Commissioner Fielder, can you hear us?
Yes, Mr. Chairman, I'm on.
All right, thank you, Commissioner. Good morning, everybody. Time is now 9:31 a.m. Today's date is Wednesday, January 19th, 2022. This is the time and place for our regularly scheduled business meeting. Would the commissioners join me in reciting the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, commissioners. And I would note for the record that myself, Vice Chair Johnson, Commissioner O'Donnell are present in the Bollinger Room. Commissioner Fielder is participating remotely, and Commissioner Pinocci is excused this morning, but may be joining us. He's having some travel delays due to the weather. So we do have quorum. All right, let's move into our business meeting. Is there public comment in the room this morning on any matter for the commission today? Seeing none, is there any public comment online? Seeing none. There are no changes to the agenda this morning, so let's move into our action item. Action item number 1 is approval of the commission minutes for the week of January 10th, 2022. Is there a motion? Vice Chair Johnson.
We approve, Mr. Chairman.
Vice Chair Johnson has moved to approve the commission minutes for the week of January 10th, and that has been seconded by Commissioner O'Donnell. Discussion or changes to the minutes as written? Seeing none, all those in favor of adopting the minutes for the week of January 10th signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, minutes are adopted unanimously. Let's move into work session. Our first work session item this morning is docket 2021.03.033. This is commission initiated. This is rulemaking to implement the Montana Energy Impact Assistance Act. We're here to consider the draft notice of proposed rulemaking. Mr. Hamilton.
Thank you, Mr. Chair and members of the commission. As the chairman just mentioned, we have before you today the notice of public hearing and proposed adoption for the new rules that will enact the Montana Energy Impact Assistance Act. This was a piece of legislation in 2019 that is meant to provide an alternate means of financing the retirement, the replacement, the costs associated with updating our electrical infrastructure here in Montana. The Montana Energy Impact Assistance Act appears in Title 69, Chapter 3, Part 16. The proposal in front of you is the product of staff's communications and roundtable discussions with interested parties, including the Montana Dakota Utilities Company and Northwestern Energy and MEIC, to provide feedback on what was a draft that staff originally circulated earlier that was significantly revised and is now before you with the general assent of all of those parties who participated in the informal pre-rulemaking discussions. The rule is comprised of three primary parts. The first part discusses the guidelines that the companies must follow when submitting applications under the Act. It refers in that section 1 of the statute to Montana Code annotated 69-3-1201. That is the integrated resource planning statute. So in essence, the guidelines here that will guide the applications under this Act have to follow or generally be developed pursuant to the integrated resource plan for each utility. Second major part of the proposed rule is in section 2, and this is frankly the bulk of the rule, that describes the minimum filing requirements for applications under the Act. These minimum filing requirements generally track what you would find in Title 69, Chapter 3, Part 1605, or excuse me, Section 1605. Subpart 2. That statute provides its own list of what an application must include in order to be sufficient for the Commission's consideration. Of course, it would be improper for our rule to simply restate what the statute says. That's not permitted under MAPA. So it does provide additional gloss, additional understanding of how the Commission would expect that information to be presented. Specifically, it asks for testimony and work papers, and you'll see that at the beginning of basically every one of the subsections under Part 2 of the rule. If you'd like, Commissioners, I'd be happy to go through and connect the dots between Section 1605, the statute, and where those elements of the statute appear in Part 2 of the rule. But it suffices to say that what we have here is the beginning point of an application. It is not the full scope of information that would be elicited through the course of a contested case. We would accept, of course, intervention. Parties would be able to submit discovery, would be able to ask for additional information on top of what is the minimum or filing requirement here, which gets the utility in the door in the first place. It's also worth noting that this is only the notice of proposed hearing. So this does not necessarily reflect the final language that the Commission would be in the position of adopting. After we have that public hearing, after we have written feedback and oral feedback from interested parties, the Commission, of course, would be looking at incorporating that feedback into the final notice of adoption that would begin the implementation of the Montana Energy Impact Assistance Act. The third major aspect of this rule is Section 3, which appears at the bottom of page 2 of the notice. That is the administrative penalty. Of note here, it refers to another statute in Title 69, that's 69-3-206, which is our administrative penalty statute for the failure to provide reports upon request of the Commission. The penalty provided in that statute ranges from $100 to $1,000 and requires the Commission to undertake a civil district court action to collect the penalty. The thought in Section 3 of this rule is to harmonize the method by which the Commission typically collects penalties with our existing statute. So if the legislature later decided to change that statute to amend the amount of the penalty or to change the process through which the Commission would recover the penalty, they would automatically be reflected here in what the Commission has adopted as a rule. I shouldn't say automatically. It would require a new notice of adoption to incorporate the latest version of the statute, but the idea is to make this mirror every other civil penalty that the Commission would pursue. The schedule hearing for this is March 7th at 1:30 in the afternoon. It's my understanding that the commissioners are generally available at that time, but this notice of proposed rulemaking does allow the Commission to delegate to staff to preside over that hearing if there is any sort of scheduling conflict. With that, I would just note that we have been in contact with the bill's sponsor, the Act's sponsor. She is generally supportive, is my understanding, of the current draft of the notice of proposed rulemaking. So with that, I'd be happy to stand for any questions that the commissioners may have.
Is there a motion? Commissioner O'Donnell?
Yes, Mr. Chairman, having read over the recommended proposed rule, I find it to be incredibly comprehensive, and especially on the insights into all of the difficulties that come along with the bonding the very legal requirements of that. So I find it to be, it seems to me, not being a person well versed in that bonding, but seems to be very, very comprehensive. And I really applaud staff for that and move that we adopt this draft recommendation.
Is there a second, Vice Chair Johnson?
Second the motion, Mr. Chairman.
All right, we have a motion and second. Commissioner O'Donnell.
Thank you, Mr. Chairman. Lucas, I just wanted to be clear on some things on here. Again, you use the word harmonization of, and I'm looking at with House Bill 467 from the legislature in 4 years ago, 2 sessions ago, 3 years ago. That it begins by saying, whereas customers of Montana's regulated electric utilities have an interest in ensuring that their utilities are providing efficient and cost-effective electric generation. And then it goes on from there. But the overriding concern on this is not a financial one, but having to do with the very reason that the Public Service Commission exists on the thing. So what I'm concerned with is whether or not, where you would talk about whether or not the presence of the means, the mechanism of securitization requires the commission is to any course of action. What I'm contemplating is if any regulated utility, for instance, talking about retirements, decided to retire some property prematurely, that and that we disagreed with that, that the stranded costs should be borne by ratepayers. Is there any obligation in here that you see that we would be in a corner to approve that or not?
Mr. Chair, Commissioner O'Donnell, the short answer is no, as I understand the question. And just to elaborate a bit, nothing in the Montana Energy Impact Assistance Act or the proposed rule that you have before you limits the commission's discretion to make the determination of whether costs incurred by the utility are reasonable and prudent, that they satisfy the standards that the commission would otherwise look to satisfy in a rate case for determining what to do with certain assets. So it still remains the obligation of the utility in one of these applications to justify the costs that they seek to securitize. And it still remains within the commission's authority to determine that those costs are not reasonable and prudent. Does that answer your question?
Yeah, pretty much, yes. I also noted from House Bill 467 that in Section 18 of that, the securitization anticipated on here is not just for retirement stranded costs of retirements, okay? But having to do with, I'm reading here, Section 8, to build and own generation infrastructure and facilities that are least cost generation resources, to build, own, or purchase electricity storage capacity, to invest in network modernization, of which Commissioner Panocci, thank you for his really interest in that area, to replace any damaged or destroyed electric infrastructure or facilities. I just wanted to point out that that is there. And do you see our rules for securitization having any impact on this, or we're just simply talking about the process of applying for securitization? Is that correct?
Chairman and Commissioner O'Donnell, the rule would certainly be necessary in order to allow an application or to have a process for the application that would seek to invest in new resources, in whether that resource is brand new or a replacement for something that already exists. So the rule is definitely necessary in order to have a later application and a contested case that discusses that sort of asset. Does that answer your question?
Yes, and one of the things I noted in reading your draft here is that it would securitization would basically require a significant savings to ratepayers rather than just the utility assuming that and passing it on in the ordinary way. I think that was a very insightful notation on there, that would be a requirement, so that securitization, the purpose of the bill, and that the reason for the legislature passed it and it was signed into law was that the situation, circumstances in any cases is going to be different, and it gives the commission flexibility on whether or not to do things in according to what the commission feels is in the public interest. So, Mr. Chairman, thank you for allowing me these questions.
Thank you, Commissioner O'Donnell. Additional discussion? Vice Chair Johnson?
Thank you, Mr. Chairman. Mr. Chairman, if I might, I just have two questions. Both, I guess, kind of unrelated. Mr. Hamilton, first, just sitting here listening to your description of what is going to be done with fines and harmonizing that with the process, et cetera, it occurred to me when we're talking about fines from $100 to $1,000, what would you guess our out-of-pocket legal costs are to go to district court to secure a $100 fine against an entity?
Chairman, Vice Chairman, they would easily exceed the amount of the penalty. And to get to, I think, the question that you're leading to, perhaps it would be time to revisit that statute and update it.
Well, and you are in fact ahead of me, but would it make sense, or is the possibility as we're going through this process now to somehow change that structure in a way that would allow us to recoup legal fees from the entity over and above the fine? We've got this kind of dichotomy. We don't keep the fine money, so we're out every penny that we spend to assess and the fine. Is that something that could be pursued through this process?
Chairman and Vice Chairman, by this process, do you mean the statutory process or a look at the statute?
Yes, if we're going to, can this be the catalyst to revisiting that statute and perhaps making it a little more effective for us?
Mr. Chairman, Vice Chairman, yes. Short answer. Longer answer is I think that the statute is worth revisiting independent of the Montana Energy Impact Assistance Act.
Thank you. And follow up, Mr. Chairman, if I might.
Follow up.
Unrelated to the fines, Mr. Hamilton, we're clearly not the first state in the country that is or will be faced with dealing with the impacts of closures of these assets. Are we, with this rule and this process, are we reinventing a wheel? Are we plowing new ground? Have we looked with some clarity at what other states have done along this line? Are we perhaps in a position where we can learn from other states' mistakes as we move forward to this? What kind of due diligence has been done in that regard?
Mr. Chairman, Vice Chairman, the bill itself, as I understand it, was borrowed from another state, and I'm going to check behind me here. Is Indiana?
Indiana.
Yeah. Indiana, I believe, was where much of the language was drawn from. Other states, of course, have also pursued a securitization option for this sort of investment on the part of a utility. And New Mexico is a good example, perhaps, of one state that has recently gone through a contested case to create a securitized method of dealing with the retirement of assets. And I know that one member of regulatory staff who is not present in the room today, Gary Duncan, has been working with his contacts in New Mexico to learn about that process. And we will continue to have those discussions about the lessons that can be learned from other states to make sure that when we do have a contested case on this subject, we are asking the right questions and have the right information for the commission to make a decision. In terms of the threshold process, which is sort of what this rule outlines, as minimum filing requirements. Perhaps there will be more information that we can glean through the public process on this rulemaking that would inform additional elements to include in this rule. But as a starting point, I do believe that staff and the parties have taken the lessons of other states and incorporated them into the draft before you.
Thank you for that. That's what I was hoping I would hear. Thank you, Mr. Chairman.
Additional discussion? I would just make some editorial notes. First is that I did speak to the bill sponsor, Representative Heyman, on Monday about this draft proposal. She, as you stated, Mr. Hamilton, did give approval and was very thankful that we had reached out to her and incorporated her as part of the drafting process. So good work on that, Mr. Hamilton. And I would also say that following up on the Vice Chair's excellent line of questioning, this is a bit of a novel bill, I think, that we're doing rulemaking on. I'd like to commend the staff for taking what is somewhat of a complex subject and coming up with a good product that we're considering today. I appreciate also that we brought interested parties in, had discussions about these proposed rules and came to what I would say is at least initial consensus on moving forward. Obviously, there will be more public comment and more process on this, but I think this is a very good starting point. And let me commend you, Mr. Hamilton, and the rest of our staff for getting this bill to this point. Additional discussion? All right. All those in favor of Commissioner O'Donnell's motion signify by saying aye.
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 All those opposed, same sign. Seeing no opposition, I would note for the record, by the way, that Commissioner Pinocci did join us. Morning. All right. Motion carries. All right. Let's move to work session item number 2. This is commission initiated. This is litigation status update for the commissioners. Legal staff will provide an update on currently pending litigation and discuss litigation strategy involving the agency. The next session of our work session will be closed to the public. I would note for the record that the presiding officer of any meeting, which would be me this morning, may close the meeting during the time discussion relates to a matter of litigation and/or litigation strategy, and the presiding officer determines the need to protect agency litigation decision-making, and such discussion exceeds the merits of public disclosure. The discussion in this closed session will involve discussions and decision-making related to ongoing agency litigation in which the agency is involved as a party. And accordingly, as the presiding officer of this meeting, I determined that the merits of agency legal strategy and privacy of the same outweighs public right to know. So I am closing this meeting to the public. Upon the conclusion of this work session, today's business meeting will be adjourned. So commissioners will adjourn to the commission conference room for further discussion.